welcome along another of our series of interviews with specialists in a particular area that we think will be of great interest to you as business owners. This week I have Hayley Mauro, who is a dispute resolution partner with Wilson Browne Solicitors in Kettering, specialising in company and commercial disputes. So hello, Hayley.
Hi.
Yeah. So look, obviously COVID-19 is the big issue at the moment. An awful lot that's going on. Big interest from a business owner's point of view. I think the first question is, what does a business owner need to do to protect themselves during COVID-19? So I suppose in particular, does a business need to do anything specific legally for the public coming onto their premises?
I think what I would say is you've always got to be mindful of health and safety legislation that will apply regardless to your workers or non-workers. Follow good practice, so government guidance, and also follow the restraints of your insurance, because what you can find is you can have people running a business from the same venue, so obviously within the same tier or area, but because of the restrictions on the insurance, they're having to do things slightly differently. So I think, just make sure you do that due diligence for those checks so that you're putting in the safety measures required. But not only that, you don't want to be in the firing line for any fines or enforcement from the local health environmental officer. So provided you're following those things, and also making sure there's any sort of training requirements met internally so that everybody can stay safe, they would be the key things that would initially spring to mind.
So it's much more about applying your common sense and applying the rules than it is about anything that you need to think about from a legal perspective.
Yeah, and making sure you've got the insurance, because what you don't want to do is do something, then find that you're on the hook for a claim or any issues, and then you haven't got the backing that you thought you had. Yeah,
so is insurance likely to change with COVID-19, or would that pretty much be your standard insurance still?
The insurance, there's a test case going ahead at the Supreme Court at the moment. It's been appealed, and it's particularly looking at all the issues to try and get some common ground. So they're looking at 21 policies at the moment with the worded, because what we are finding is a lot of the insurance providers are going back to how things were underwritten and thinking, well, that's not quite what was meant by this. And so there's lots of claims. It's quite a fluid area at the moment, very, very busy. So we're hoping to get some guidance. There has been, it's being appealed. So when that comes out, whilst it's only going to apply to the actual parties, it will give guidance to everybody else in the industry, be it policyholders or insurance providers. So what I would suggest, if you're not quite sure on what the position is, or you're thinking of taking out some insurance because this has happened, to make sure you're protected, then to check the policy, speak to your insurance brokers or who you liaise with, because it's not a one case fits all. Mm-hmm. It comes down to the wording of your contract with the insurance provider.
Okay, that makes sense. Yeah, and I suppose you raise a good point as well, actually, because it's very new legislation. It's got to be tested, doesn't it? It's got to actually see what the rules really mean in reality.
Yeah, and the way it's been worded. So hopefully we'll get some more guidance. But it's important to be able to rely on it if you need it. And obviously now this has happened, if you're considering renewing your insurance, then it's the ideal opportunity to just make sure certain events would be covered. And if it is down to how it's worded as to what's happening within your area, even though COVID has affected, nationally and beyond, it's looking at things, what evidence will you need if you need to make a claim? So, being mindful and keeping records of statistics, individual cases that you can refer to within your actual area, and guidance if it's been mandatory for you to close, or if it hasn't been mandatory but you're relying on other provisions.
Yeah.
Just being mindful of what you need to be able to evidence that why you've done what you've done, be it business interruption, and then you're trying to claim losses.
Okay, that makes sense. And I suppose that another area is the execution of work as well, because I'm sure there's a lot of businesses that are unable to perform their contracted work because of COVID-19. So what position does that leave a business owner in? I guess there's two parts to this as well, aren't there? There's the first of all, from the point of view of a business owner who is having goods or services supplied to him, and then of course there's the business owner who is supplying the goods. So I don't know which angle you want to handle that from first of all.
Yeah, I mean, as you would expect, at the moment we're seeing an increase on contractual disputes, people wanting to get out of contracts because they're not impossible to perform, but now as a result of what's going on, they're more financially onerous, and therefore they would like to try to get out of them. So again, it does come down to your contract. Are you able to rely on a force majeure provision that is triggered by COVID? In which case, what does the contract allow you to do? Because within that, depending on how it's drafted, it could allow you to terminate the contract without penalty. If it doesn't, then you're less likely to be able to argue that then it gives you the break that you need to come out of the contract. Or it might be that you're not wanting to end the contract, you're wanting to be able to continue. So what I would suggest is that you review your terms and conditions to make sure they do what you want them to do in this sort of situation. And if you've got contracts, they need to be looked at. And can you argue it's frustrated and you're no longer able to perform the contract? And therefore, what you're looking at in those situations is anything that's owed up to the date of frustration would still fall due. And once it's frustrated, that severs the contract. But as you can imagine, it's not, that's a whole area in itself. And we're seeing lots of arguments for people trying to get their deposits back, and whether they're refundable, or whether they can turn around and say, well, no, actually, you need to put it off to an alternative date because we can't do it on this date, but we're not ending the contract.
Yeah.
So it is, and I'm kind of sort of going around the houses, but it does depend on what you're tied into, particularly business to business, because courts will take the view that you're treated as being more business savvy and aware of what you're entering into. And if there's an express provision to show what the intentions were at the time, then you're going to be held to that. So if you just come out without an agreement or being able to, then you're going to be held in breach of contract, and they may seek to pursue you for damages.
So what's the bottom line here then? Because I can see situations where actually building must be a great example. So if you are constructing a building for somebody, and up until probably March everything was going fine, you're on schedule, then March hit, and of course all your staff would probably have had to be furloughed, so that you wouldn't have been able to continue with the building. So from the supplier's point of view, they're obviously in breach of contract legally at that point, but actually legally they're not allowed to continue, which then puts the customer in quite a difficult position, whatever that business is. So is this just a case of whatever happens, you basically just got to get round the table and negotiate?
Communication is key, because you also want to find out what's going on, because you may need to use that information as to, what you can do, whether you're able to hold them to the terms of the contract, and whether you want to do that or whether you can still make it work another way. But also, if you can't resolve it and you've been left effectively high and dry and you want to hold them to the contract, that information may give you what you need to know as to what enforcement action you can take if you have to take it further. So, for example, what we have seen in the last, this year, is legislation being passed through Parliament. Ordinarily would take a couple of years, is being passed through within a matter of months. And so you're having restrictions on, your commercial landlord. If people aren't paying rent or they're not able to trade, you're then having issues in that you can't seek to take possession of the property, because if they're not paying as a result of COVID, things like that. So there's all these other restrictions coming into play as to what you can and can't do. So, depending on how they bite and affect you, may affect your appetite of what you're prepared to negotiate and how you're prepared to resolve it. So if, say, on a sale of goods and supply contract, there's been an amendment to the Insolvency Act as well. So it's not just with regards to your property not being able to take, forfeiture proceedings or statutory demands if it's relating to non-payment, but it's also affecting goods. So you could have in your contract an express provision that will allow you to cease to supply if you're not being paid, to terminate the contract. I mean, it's all advisable things to start having a look and review contracts in these times to make sure they do as much for you as they possibly can.
Yeah.
But then there's been legislation passed so that if, as a result of COVID, there's a business that's struggling and restructuring, then you're not able to rely on those provisions biting. So there's other restrictions. So what I would say, if somebody is considering what they can and can't do, it's always advisable just to get some initial advice.
Yeah.
And if you're in it, just so that you can then make sure that you're putting your best foot forward and tactically as well as legally, and you're mindful of the other restrictions that are coming in. Because yes, you can still do things, but you need to know what you can and can't do as to how best to play it.
Yeah, I think actually that was the conclusion I was coming to. Actually, this is sounding like it's complex, very complex, and actually getting advice, and it's all the ins and outs of the issue here, isn't it? All the other bits of legislation that come into play, plus any existing cases, which of course you're aware of, that the rest of us may have no idea about.
Yeah, and it's just then having that initial advice, be that for myself or another solicitor, can pay dividends in the long run, because what you're not doing is running down a particular road, investing time, energy and resources that could be best spent elsewhere, only to find that actually, you should have took a left further down the road. And now you're sort of trying to reinvent the wheel and go in a different direction. So
I suppose it's that initial advice, allowing you to have a cup of coffee and reach an agreement with the supplier or the customer informally, if you like, is going to be far easier and probably far cheaper than racking up bills for legal assistance to take it to court and everything that's involved.
That's right, and just having the initial advice that actually, if you can't sit around the table, if you can't get a satisfactory outcome, what position you are in, so that at least then you can take the commercial view and how best you want to play it when you're sat around that table as well.
Yeah, of course. Which actually then opens up another question as well, doesn't it? Because we've so far really talked about contracts that are in existence before COVID started to kick in, but there's also, of course, business still goes on. People are still doing business even with the restrictions in place. And so what would a business do now to protect themselves and ensure that they got paid for doing the work, even though let's face it, from where we are at the moment, we're in lockdown at the moment. That all finishes in a couple of days' time, and we go into tier 2. Then we've got even further easing over Christmas, and then we're going back at. Nobody knows what's going on. Is the bottom line, isn't it? It's very difficult to guess what the future brings. So, what would a business do? What they have in place to make sure that they were paid on time from a contractual point of view?
I think you're right, because there's a lot of businesses that are, that have started during the pandemic and are doing very well, and business is certainly carrying on, depending on the industries. And I think what it'd be always worth doing is, have your terms and conditions reviewed, revisit them. It may be you had something, cobbled together or something in place or drafted for you when you started out. Your business may have altered anyway, and developed in a slightly different direction. So it's always good housekeeping to do. But you'd be looking at, do they give you, the maximum amount of protection that they could do? So, if you're supplying goods, if someone doesn't pay, have you retained title to those goods? Are you able to go and already have the right to go onto the premises to retrieve those goods, so that you're not getting in the territory of trespass and things like that? What are the credit? What's the credit period? What's the insurance? You don't have to have a credit period. It could be payment on invoice. What's the interest rate? Do you want a contractual interest rate? if you rely on the late payment commercial debts interest legislation, then there's fixed compensation amounts that can be added on. But I think it is a case of just taking the stock, looking at what systems you've got in place. Look at your age debts.
Yeah.
Look at your debtor book. How can that work better for you? Because in these times, if you're not actively chasing or staying on top of things, before long, things can get out of control, or it's a long debt. Someone's thinking, well, you're not really going to do anything about that, so they'll put you to the bottom of the pile. So it's just making sure you keep that communication, review your terms and conditions so that they do what you want them to for you. So in this situation, if there's when you want to be able to say frustration, force majeure, but I do keep coming back to communication, because I think if you're entering into contracts as well, you also want to be able to do your checks against the company, make sure you're comfortable with who you're trading with, but also if there's any signs when the relationship is relatively new, that you're aware of what's going on, so that you can take action quickly in order to get paid. And I think it's just being vigilant and not letting, we can all fall a victim to it. You're busy doing the work and meeting deadlines, and then before you know it, you realise, well, someone hasn't paid you, and it starts accumulating.
Yeah.
So it's just making sure that you stay on top of things.
Yeah, I suppose it's normal business good practice, actually, isn't it? It's understanding what are the key measurements, what are the key performance indicators in your business, and making sure that you are monitoring them on a very regular basis, which is probably going to be, well, I'd say, at least monthly and probably weekly. You need to be measuring that performance, and also, of course, making sure your suppliers are conforming to their contracts as well, to make sure that all the pieces are lining up.
Yeah, you might as well want to be thinking about, do you want to deposit, interim invoicing, so you're not just waiting till the end, because there's a lot that can happen.
Yeah. Yeah, which is actually standard cash flow management as well, isn't it? So have stage payments in place when you put the contract together, and very clearly define what has to be delivered at that point for that payment.
Mm-hmm.
And so the other question is, of course, if it does get to the situation where a business owner has bad debt, what are they able to do to recover that debt at the moment? Has anything changed substantially, or has the advice changed as a result of COVID?
So with regards to if somebody's in difficulties and they can't pay?
Yeah, or even just refusing to pay, because let's face it, some people will be trying to extend their payment terms to keep the money in their bank and keep them afloat, rather than give the money to another business.
Yeah, I think as well there'll be those that be trying to take advantage of the situation. I think it's a case of not letting the grass grow for too long, for want of a better expression. I think it's have your debt recovery in place and be sort of active, keep the communication going. If you don't feel comfortable doing that yourself, then you could get someone else to do that. I know we have a package for straightforward sort of non-payment of invoices. We could speak to people about that, because 9 times out of 10 you get a letter for action from a solicitor, and it can bring them to the table to start talking. If they think, well, actually, I can keep telling you this has happened, and my Aunt Lucy and this, that, and the other, and play for time. Once then you start doing the letters for action, they'll know that effectively, if they don't resolve it, what the potential consequences are, whether you choose to act on them or not. So I think it's debt recovery, but bear in mind what I've said previously, to know what the situation is as to what action you can actually take at the moment. Yeah,
absolutely. Yeah, and you raise a good point as well, because this is all about cash flow fundamentally as well, isn't it? So if you look at it from a business owner's perspective, it's about having the money available to your business, and also, of course, you are not lending money to another business without at least having the capability to charge for that money as well, whether that's the interest rate or however you want to apply that.
Yeah.
So the other side of all this, of course, is that there's going to be a number of business owners who inevitably are not going to be able to continue trading through the current restrictions, and are probably looking to recover as much value from their business as they possibly can, which probably means they're going to be looking to sell it. So what advice would you have for those business owners at the moment?
I think it's a follow-on for what we was talking about, because if you get your house in order with regards to your age debtors list, that's going to clean things up and make it a more viable option. Also looking at things like your existing contracts regarding assignments and innovations, so that they have added value if someone wants to come in and take over. Also looking at your leases, obviously depending on how long you've got, will depend on what measures you can actually put in place. So if you're looking at a 5-year plan, say, then you might be looking at, okay, well, we've got a lease renewal, we can start renegotiating terms. The same with contracts. If you've got personal guarantees that you've entered into, then you might want to try to get those cleared, so that you've not got exposure once you sell the company. Look at your credit rating, try and work on what repayment terms, what things can you put in place, because it's all about making it more attractive at the end of the day, and insurances, and just trying to put your best foot forward so that you maximize the value. And one thing that people will look at will be, if you've got ongoing disputes with employees, if you're subject to litigation at the moment. So, you might want to be trying to resolve matters and close things down, and trying to avoid getting any sort of CCJs yourself if you're in dispute, non-payment. And that could be a matter of, negotiating repayment terms and keeping everybody happy, but also maximising the value of the business. So looking at, have you got the licenses and things you need for intellectual property? What do you need to do to try to add value to the business in that way, and also start working on increasing the goodwill in the company, because that will all add to how attractive it is, and effectively when you get it valued, how the company is going to be valued.
It's a good point, Jim. There's definitely a difference between somebody who's trying to sell the business now almost as a fire sale and not having time to organise the company in the best possible way to get the maximum price, as to somebody who's maybe looking to sell in 3 or 5 years, where I suppose from my perspective, we'll be working with them to demonstrate they are not fundamental to the success of the business, and actually start to remove them from the business, as you say, clear up everything that surrounds them in terms of where they owe money and any contracts and the relation that has to them, to free up the business to make it, if you like, the most attractive proposition when it comes to selling it. So I think I suppose it's that difference, isn't it, between actually, if you had to sell it today, where would you be, as opposed to if you're going to sell it in 3-5 years time, when you've actually got time to put a plan in place and execute that against that plan to realise the best possible price for the company.
Yeah, I think the other thing to bear in mind, obviously, the current climate is you've got a lot of people at the moment thinking, well, I'm manageable for grants. So, not necessarily having joined up thinking, and so we'll tick the box to say we're struggling, we'll get the grant and have that, cash injection. But then that can have a knock-on effect. I've been informed by someone recently that lenders are starting to have a look, particularly if someone's self-employed, to for lending on them, have they been struggling? And one thing that they'll ask for will be the information for the grants where you've actually openly ticked there you've been struggling. So it's kind of looking at things as a whole as opposed to individually, because it can have other impacts on you, as opposed to thinking, well, actually, I'll qualify, I'll get the money, and do I actually really need that money at the moment?
And then of course there's a number of people that are going to be taking the loans and the grants and putting them in their bank account simply so they've got the money if they need it, or even replacing existing loans because it's a far better interest rate with some of the COVID deals that are available at the moment. Yeah,
it's just that thing that you might then find you needed to get a loan, and then it's being considered and it's actually stopping you from then being able to do that.
Yeah, Yeah, absolutely. So with everything that's going on at the moment, what are the most common questions business owners are coming to you with at the moment then, Hayley?
I would say it's non-payment,
Mm-hmm.
breach of contract related arguments. We are seeing an increase on your building disputes, and particularly I think a sign of the times, everyone's spending more time at home, and we've had a noticeable increase in the amount of adverse possession claims. So that's where effectively, like what's referred to as your squatter's rights. So people have been using and maintaining an area, and suddenly I say people at home, someone else is trying to use it and thinking, well, hang on a minute, this should be my land, and then they are applying to acquire that. So that's something that's been very noticeable. But mainly sort of on the contractual side, in how to get out of a contract or how to hold someone to the contract in these times. I think one thing as well is with regards to, you know, your commercial property litigation on, you know, that's sort of been on the increase, should I say, on what can actually be done in accordance with the lease and things like that.
Okay, yes, I suppose it's all the sort of questions you'd expect, actually, isn't it? It's just, I suppose it's taken something like this to force them to fruition as well.
Yeah, because you can have something in your lease where it says, you know, you have to remain open. Well, if you're being told you can't be open. So again, I think the main thing to come out of it is communication and making sure you're aware of everything, and you just take that advice and then make your decisions accordingly.
Yeah, I suppose from your perspective, are you expecting to see a change in the way that contracts are written post-COVID, in that people are going to have learned an awful lot from the experience over the last 9 months, and probably for you know, for the next 6 months or so, that they're actually going to take a very different view when they're drafting contracts to the way that we've viewed these sort of pandemics historically?
Definitely, I think particularly if they've had the fingers burnt, hindsight is always a wonderful thing. So I think now we've had something like this, and as I said, it's not one size fits all. It always comes down to what the commercial agreements between the parties state. We are going to see some sort of clever drafting, I think, going forward.
Yes, as you say, learn from experience. Yeah. So Hayley, that's been great. I appreciate your time today, and some really interesting insights there as well. So if somebody has a legal issue, as we've been talking about today, and they want to get some advice, how do they contact you?
They can contact via the website or telephone. They could obviously ask for myself or go through to New Inquiries team, and depending on the query that they've got, they can then be signposted and have initial conversation, which will be free of charge with one of the many experts at Wilson Browne.
Excellent. So Hayley, thank you for your time today. Much appreciated. Really useful hearing what you had to say. And yeah, I'm sure we'll talk again in the future. Thanks again.
Brilliant. Thank you for having me.